All right, well, to comply with applicable laws, I guess we need to get started so we can get our time in here. Section 10, the earnest money deposit. Everybody seems a little geared up for this one. We'll skip to 10.4 because 10.1, 2, and 3 basically say, yeah, you've made this deposit. If there's no deal, you get the money back. If you enter into contract, now you've made a deposit. So what happens? That first line, if any written contingency is not satisfied or waived, is kind of the catch-all to take care of badly drafted contingencies. So if you get to some point in the contract and there's a contingency out there that hasn't been satisfied, and one of the parties, the party affected by that contingency, says, wait a minute, this hasn't been taken care of, well, then it's time to terminate the contract. And the money goes back to the buyer. If the buyer fails to refuses to perform, the earnest money should be paid to the seller. Okay. This is what the contract aspires to. The first paragraph is the aspirations. It's kind of instructions to a court of law, if you will, right? That this is what we want to have happen. The reality is in the rest of the paragraph. The reality is that as a broker, right? You're just the agent of the broker, so your broker is obligated to hang on to the money until the parties either agree to tell them to do something with it. That's A. Or no, well, until B, the parties tell them to do something with it. A, the transaction closes and it disperses the money. Or C, a court tells them what to do with the money. Or D, going to the next paragraph now. Really, this says it better. In the event of a dispute, okay? Written instructions, dispute resolved, number 1. Number 2, court order, says what to do with it. Number 3, there's a dispute, there's no written instructions, 2 years pass. Now the buyer gets his money back. But D, what happens if the broker can't find the buyer? Anyone? Unclaimed funds, that's right. So that's the way they're handled. I was talking to someone during the break here, expressed some frustration with this process. But this is the process under Ohio law now. It's pretty well comports with what the way most lawyers would draft, say, an escrow agreement, for example. That, you know, it protects, it's protection for the holder of the escrow or the holder of the deposit, because they can never be, under this regimen, your broker can never be accused of giving the money to the wrong party. So it's protecting your broker and, by extension, protecting you. Yes? You say, the comment here is that earnest money, you've been told that earnest money is not required in a transaction. That's correct. It's absolutely correct.
So we can avoid all of this if we didn't go around writing $500 checks.
You could avoid all this by not writing checks. On the other hand, you and I both know that most parties are more comfortable when someone puts a little skin in the game. That's just because the theory of earnest money, or deposit as it were, right, is that some consideration, a legal term, has been given for the contract, when in fact, in this particular contract, as in most contracts, the consideration can simply be the mutual promises that the parties make. I promise to sell and you promise to buy on these terms and conditions. That's mutual consideration. That's a contract. Consideration does not have to be money. And that's where you hear that. There doesn't have to be earnest money. It doesn't have to be a deposit. But just as a matter of fact, most people want it. Matter of fact, not only do most people want it, I run into a lot of sellers say, really? Only $2,000? Can't I have more?
It's awful easy to walk away from that. Awful easy.
I think if you have a contract that's willing to be offered better.
Well, again, I'll get into the pros and cons of that in a second here. But go.
I'm running into where it's a bank-owned property and the bank says that the money's non-refundable, and when it closes, they want to pay the listing broker with that money.
That would be you say you're running into a contract now, let me get this straight here, where the earnest money is paid over to the holder of the deposit, which is typically the listing broker, and as for payment of their services, and then it's credited back to the buyer somehow or another in the calculation of the purchase price. I am an advisor to the Standard Forms Committee here, and we've been talking about that very issue, and it's an issue that makes a lot of people uncomfortable. But Coldwell Banker does it. As far as I know, as long as it's not used as a tool to extract an undue advantage in the contract process, I don't think that the Real Estate Commission's ever going to find it to be illegal or to outlaw it by rule somehow or another. But I also don't see that particular practice spreading very far because it can be an awfully funny from an accounting standpoint, because it's much easier from an accounting standpoint to see that check go into your trust account, then go back out of your trust account into the transaction where it belongs, then you get a check as a broker from the transaction. That's clean accounting. The other one gets, that's Caldwell Banker's choice, but it's a little interesting from an accounting standpoint. Yes?
Basically, when we're reading through the contract, we're representing the buyer. You're telling the buyer under paragraph 1.3, this contract, if they can't get a loan, the contract shall terminate, earnest money shall be returned to the buyer pursuant to paragraph 10. Same thing in the inspection report. If you don't like the inspection, the contract shall be terminated, the earnest money deposit shall be returned to the buyer pursuant to paragraph 10. In reality, it won't get returned unless the seller and the buyer both sign something, correct? Or somebody sues each other. So I almost feel like it's a little disingenuous to be saying through this to the buyer, oh, don't worry, if you don't get a loan, the contract says you get your money back. Oh, don't worry, if the house fails its inspection, you get your money back. And then when it comes time to, fish or cut bait, oh, we were kidding, you can't get your money.
It's actually a good point. I like the point. I'll repeat it. All of the provisions in this contract that state that the money shall be refunded to the buyer, right, and there are several of them, are made pursuant to this paragraph 10. And at the end of the day, while they should, by all's right and holy, get their money back, the seller still has to agree to it, or the broker has no choice but to hang on to the money. As a practical matter, in the more basic situations, is the seller going to refuse to sign? Probably not, but it could happen. And then they might just end up waiting for 2 years. Is the seller going to initiate a lawsuit over something that he knows he can't win? Probably not. But could he just sit on it for 2 years? Probably so.
So how would you advise the buyer? If you're going into this contract and they're asking you about earnest money.
I would say, A, don't give them any more earnest money than you feel comfortable giving them. B, if something goes bad, you'll in all likelihood get it back, but I can't in a timely manner, but I can't guarantee it. So I don't know what else to tell you. That's the best way to advise them. If they say, will I get it back? In all likelihood, but I can't absolutely guarantee it because the seller's going to have to agree to it. Yes?
Can't you write something in, the contract that says if, you know, these things aren't, the inspection cost or whatever, the seller must agree to give that.
You can, but the
You
brokerage is not gonna take a chance. In my experience, is you can, but if you go to the brokerage and say, hey, I want you to cut a check back to Mrs. Buyer, the brokerage is not gonna do it unless they've got one of these things, so they're not gonna get sued.
note this wording of this too. The broker is required by Ohio law to maintain such funds until he receives written instructions. If there's a dispute, he's got to get the instructions. The broker's not only not going to say, I'm not comfortable, he's going to say, I have no choice but to hang on to that money regardless of what other contract provisions you write to try to guarantee that they're going to give the money back. And that's your question really, is can we write past this? I think the answer is no, you cannot write a contract to write over this particular provision. Can't be done. Wilma.
I'm actually writing where the earnest money is, that the earnest money will be deposited within 48 hours after buyer and seller come to an agreement regarding the requested remedy.
You can do that. You can delay the deposit of the earnest money pursuant to, by amending the contract in that way, through an addendum. And that can be a good practice for the buyer in particular. It could put them in a bigger comfort zone. But again, it's a negotiation, and in this market, the seller will probably agree to it. In 2005, they wouldn't. Yes?
For REO properties, sometimes they have title control over the owner, so that we can have money.
You say for REO properties, and typically if you're dealing with an REO property where the title agent's going to hold the money, which is your comment, is that they're going to impose their contract over this anyway. Right, it's typical that in an REO transaction, one of the things you're going to run into is they're going to have a whole new contract. Yes?
Could, going back to paragraph 1.2, if we were to put a period after buyer and strike out pursuant to paragraph 10, wouldn't that get the earnest money back to the buyer if there's not performance at that point?
It still's got you the same problem because E is not just a contract term, it's a recitation of Ohio law. Right, broker's going to say, fine, you wrote that in the contract, we don't care, that's the law. Just don't do earnest money. Okay, well, let's talk about that for a minute. 10.5 is important, okay? Because, yes, earnest money is important because it puts a skin in the game, but just remember that earnest money is a completely separate issue from breach of contract. So, as the seller, you can give the buyer their money back and turn around and sue them, and vice versa. Or you can refuse to give the money back and nobody sues. It has nothing to do with your legal rights otherwise. It's a completely separate issue. Now, a court will look at that earnest money and say, gee, they got $5,000. There were $10,000 in damages. Well, that $5,000 is going to be credited, right? You already got $5,000. You're only entitled to $5,000 more now based upon that guy's breach. Okay, but retention or giving up that money is a completely separate issue. The question is whether you want someone to have a skin in the game so that they feel right now there's some urgency to do what they're supposed to do under the contract. Anyone? Okay. Almost done here. All right, here's number 8, for those of you who are counting. Professional advice and assistance. You're telling the parties to get help. There are a lot of disciplines here. You know, for the average person, do they need an accountant typically to buy a house? No. If you're talking to someone with a fair amount of money, I just did some work on a $2 million house today. I'll bet they hired an accountant to help them deal with their transaction. They had a lawyer because the lawyer was drafting up a trust because they didn't want to have their names seen in the public record. I guarantee they had the property inspected, and if they built it, they probably retained a building professional to oversee the building process. So you can have a lot of professionals involved. Second paragraph. It's very nice. This is section 11 of the paragraph is the broker's CYA section. Okay, it's a bunch of CYA stuff here, and this second paragraph is more CYA material, but you know, this is we started at the beginning of the hour. Be careful. Be careful when you recommend professionals. Okay. The phrase my wife likes to use, if I remember correctly now, is when they recommend an inspector or 2 or 3 inspectors, they will provide their client with a list of 2 or 3 inspectors. These are inspectors that our clients have informed us they've had success with. So you can make kind of a side-handed recommendation without you having endorsed them in any way. You're just saying, people have told me these guys are good. Here's their names. Go talk to them. Okay? But you don't want to say, this guy's a great inspector. He'll do a dynamite job for you. Because the first time that goes wrong, and especially if the inspector is not particularly well insured for malpractice in any sort of way, the enterprising lawyer representing your buyer is going to be looking for a pocket to sue, and that pocket will be your broker. Now, attorneys, accountants, you're on a little better ground. If you hire me, for example, and I screw something up, as an attorney in Ohio, I have to carry a very large amount of malpractice insurance by law. So they're probably not going to be looking at your pocket on that one. But there's a lot of other people in this process who may or may not be well insured, may or may not be around to sue by the time something bad happens. So be careful about how you recommend people. Winding down, residential property disclosure form. I know I'm not going to dwell on this. You're all familiar with it. Realize that when it says most sellers, it means most but not all. If the seller is a non-resident, if the seller is a bank, for example, the bank's not going to provide you with one of these forms. If the seller is a fiduciary in an estate, they're not going to provide you with one of these forms because they have no knowledge. It's that simple. And also realize that if you're a buyer agent and this is a form that should be provided, just make sure it does get provided. It doesn't provide the buyer with blanket protection. The fact that you didn't provide them, because if you look at the buyer can rescind based upon failure to provide this document, or based upon something contained in it, but the rescission has to be delivered prior to all 3 of the dates: the date of closing, 30 days after the seller accepted the buyer's offer. So you go into the contract, regardless, if it doesn't get provided 30 days later, you no longer have a right to rescind based upon your failure to get this document. So get the document. 12.2. This is the merger clause in the contract. This contract constitutes the entire agreement, and there are no representations, oral or written, which have not been incorporated. So be careful that everything that you do, every agreement is in this contract for starters, and then going forward, if there's an agreement, it needs to be the subject of a written addendum.
More and more you're seeing lenders come back and say, I don't want to see this in the contract, whether it's a concession or whatever that's going back and forth. And they'll say, put it on a separate addendum and take it out, I don't want to know about it. I'm always uncomfortable with that because it seems like it doesn't smell right.
The question, the comment is that lenders are saying we don't want X in a contract. If it's a concession, usually it's a cash concession is what you're talking about, is money for something here. And they want to put it in a separate document, an entire separate document. If it's, I don't blame you for being uncomfortable with that. I mean, ideally as a lawyer, I'm saying get it in this contract. On the other hand, a concession purely for cash, that is subsequent to this contract, done after the date of this contract, and is not part of this contract, can be considered in and of itself a separate contract, and the mutual consideration for it's not a real estate contract per se, but I could conceive of it as a contract where the consideration is that each of you will continue in this deal. But that's uncomfortable. I don't blame you. But again, lenders, especially in this market, lenders' demands drive the deals. And you have to deal with that as best you can. And if you get uncomfortable with it, call that team member of yours, call the lawyer. That's where you want that lawyer on your team. You may not even be paying him for this particular transaction, but I think you get a lawyer on your team, that you're referring business to, and you call him and say, I don't have you in on this deal, but I got this little problem. What do you think of this? And he can give you a quick answer. That's the kind of person you want on your team. The same thing with a title agent. You may not have a transaction with a title agent. You may have to be forced to use that title agent that the bank wants to use. But you got that title agent on your team and say, I've got a problem. I don't have this deal with you, Mr. X, but here's the problem. If he's part of your team, typically they'll give you an answer. They'll help you out.
Isn't the danger in that case that separate document could be subsumed into?
And again, that's why I mentioned why I say I'm a little, I can think of a good legal argument why it would be its own separate contract and enforceable as its own separate contract, and why a court would probably look at it and consider it to be enforceable on its own terms.
But the danger is it might not.
That's right. The danger is, and until a court of law speaks authoritatively, we don't know this for sure. And these are new things we're seeing. So you see new things, and the law's not settled because it's new.
We used to do side agreements,
You used to do the comment is you used to do side agreements about what now?
chattel.
About chattel? Oh, chattel agreements? Well, a side agreement for chattel is clearly not a real estate contract. And I don't think there's any question that you can say, let's say that Ned has a horse on his land, and you want to sell the horse to Joe, who's buying the property. That's not the. Lenders will tell. Some lenders will say that we don't want that in the real estate contract. Fair enough. You don't have to do that. Put it in a separate contract. It's a contract for chattel. Ned's selling Joe the horse for $100. Closing is, whenever it is. It's the more questionable thing, I think, is the concession you were talking about. It's like there's a condition on the property, and we're going to make a concession of $1,000 going forward, and the bank says we don't want to see that $1,000 in the contract. Well, arguably, it's still kind of part of the real estate contract, since the subject of it is real estate. And that's uncomfortable. I don't blame you.
Like when you do a waiver remedy, in lieu of, fixed concessions towards, closing costs.
Yeah, concession towards closing costs is another one. It's kind of part of the deal. Yeah, and they don't want to see it, and yet it's part of the real estate contract, and it's subsumed under that clause, and yeah, you got problems.
They don't want the remedy language, they don't want to know that you did a concession for closing costs in lieu of the remedy.
Well, and that kind of thing even gets more uncomfortable where you're giving a concession for, a concession in closing costs because, now the bank doesn't want to see it on the HUD, yet legally it has to be on the HUD because you're violating RESPA if you don't do that. Yeah, and now you really got a problem. Yeah, now I don't know what to tell you. Yeah, because you really do. You're violating some federal law there. It might be a tree falling in the forest, but still. Signatures. I did this simply because we all like to use email a lot these days. Under this paragraph, you can't simply be swapping emails around unless there is a document, a PDF of a signed document appended to it. We've also in the standard forms committee, there's been talk of getting some standard going for electronic signatures, kind of like you've seen VeriSign, that sort of thing. I guess that's coming, but it's not here yet. So, yeah, this is Ohio. We do things way after California. Our budget deficits are a lot smaller. Finally, the thing I wanted to talk about here is that's simple enough, but what happens in a situation where the seller wants to stay on the property after closing? Even by a couple days, let alone a longer period. If it's by a few days, you want to make sure that your insurance issues are taken care of. All right, if you're representing the seller, they might want to get a few days of renter's insurance. They're taking a little risk with their personalty. You want to make sure that the insurance has effectively transferred on the structure itself. If we're going to stay longer, you might want to think about a rental agreement. Because at the end of the day, if the seller suddenly decides they don't want to leave, the buyer is stuck with having to have the courts throw them out. You have to have them evicted through legal process. That's a pain in the rear end. It's enforceable, absolutely enforceable, absolutely enforceable. But you might want to have a rental agreement for a variety of other reasons, especially if you're going to be there for any length of time, so you know what each other's rights and responsibilities are during the rental period. That's it on the main contract. Anybody, any questions on the main contract? Yes? I'm not fully under.
Additional terms and conditions, 1.5, I do a lot of board looking families, so I have to disclose on an agent that's related to buyer or seller. That's
Okay.
immediate family. If it's somebody I'm married to, or does that count as still being related to?
So like, what's the, so, so it's your husband's, so your brother-in-law. You're related. You're related at that point. By marriage, you're related. And I would, as I tell all of my agent clients and all my client clients, better to disclose, over disclose. You occasionally lose a deal by over-disclosing, but you'll never get sued by over-disclosing. So over-disclose. And you know, your reputation will precede you as someone who is forthright and discloses things. It's that simple. Always over-disclose. Anyone else? Okay. Going back then to some drafting issues. On the CBR website, there is a contingencies and addenda, because that's really what you're doing is, you guys, you know, unless you got a lawyer involved, you're drafting contingencies and addenda. One thing I've told people here is, even if it ends up that you don't use a lawyer, one of the things that you can do to protect yourself if you have anything but the most vanilla of deals is to stick a number of days in the attorney review clause. Go back to 1.4 and stick some days in there. Put a 5 on that thing. You know? Put a 5 on it. Give it 5 days, or you know, however long you can agree to there, because you know, an attorney can always fix things after the fact. So that's my first bit of advice. If you know, make sure that what you've drafted makes sense, and is what the parties actually agreed to. Use the standard clauses when possible. You've got a whole, you know, I think in one of the handouts, they've got a whole list of standard clauses that cover a variety of situations. They clearly and obviously don't take into account all the situations you're going to run into, especially in this wonderful world where we're going through bank rios and short sales and hidden liens and the like, and that we're seeing in the modern marketplace. But they're there, use them. When you draft something, make sure that there are deadlines and consequences for everything that needs to be done. So, seller needs to do X. He needs to do it by a certain time, and if he doesn't do it, then something has to happen. Even if it goes back to the buyer gets a choice. If he doesn't do it by a certain time, then the buyer gets to choose to do something. Then the buyer's choice can only be for so long. But make sure there are deadlines and make sure there are consequences. If you do a contingency, does the contingency terminate the contract, or is somebody waiving some rights? Deadlines and consequences. Avoid ambiguity. My favorite bit of ambiguity, hope this doesn't offend too many people. You can do it deliberately. This is great ambiguity. How many remember the rock song? So, is Lola glad he's a man? Or is Lola a man? You'll never know from that, will you? You can do the same thing by accident. I got a couple interesting ones that I've come across recently. During the run-up to our June 30th tax credit deadline, there were a lot of contracts written around April 30th at 11 in the evening. Here's one of them. This offer is contingent upon the sale of buyer's current residence. It's fairly typical stuff. In the event seller receives a non-contingent offer, buyer will be given 48 hours proceed to closing, or this contract will terminate. Closing to take place no later than June 25th, 2010, with or without sale of buyer's residence. Why would you do that? And what do they mean by it? The last line negates the first line. Now you got a mess. We straightened the mess out, but it was a mess. And it didn't do the agent who wrote it, whether the buyer meant to do this or not, the agent who wrote it didn't do his or herself any favors in terms of their reputation by anyone who read that went, really? You know, so you got to be careful. Good lawyers can do this stuff too, though. Here's one for you. This is in a deed restriction, okay? A large local subdivision dealing with the rights of property owners who happen to have drainage easements located on their property. Except if erected by the developer, no above-grade structures, dams, or other obstructions to the flow of water runoff are permitted in any drainage easements as shown on the plat. Let me read that again. Except if erected by the developer. So if the developer did it, it's okay. No above-grade structures, dams, or other obstructions to the flow of water runoff are permitted in any drainage easements as shown on the plat. My client put up a fence. Is it prohibited? That's right. That's right. Okay, but the homeowners association, based upon that restriction, put up a rule that said no fences in drainage easements. So I mean, that's the drafter just causing trouble, right? Because when I read it, of course I'm representing my client, so I'm going to read it this way. So wait a minute, it's a structure in the drainage easement, but it doesn't obstruct the flow of water, and I can prove it because what's the guy's name? The fellow up there who does these things up in Delaware County sent me a letter saying it doesn't do it. Told us exactly how to build it so it wouldn't obstruct the flow of water. But that's a badly drafted clause of a contract. And remember, deed restrictions are a contract. They're a contract like anything else. That's a badly drafted provision in a contract drafted by a good, sophisticated lawyer that caused nothing but trouble. And the trouble's been going on for about 2 years now. Over a fence. There you go. So, if there are no further questions, we got about a half hour left, and I want to get into the short sale addendums. You got a whole set of forms here. These are relatively new. You find them on your website. They provide a lot of structure to the short sale process. I think they comport pretty well with the uncertainty of the process. I don't know if all of you had the same experience. I've been representing folks in a fair number of short sales, and the defining characteristic of short sales is they have no defining characteristics. And they're not short. Yeah, short is money, not time. No question about that. And the lenders they all have different ways of dealing with it, and they're very inconsistent and they can be very hard to communicate with. And they've hired a lot of people who are very overburdened so-called loss mitigation specialists, who may or may not be specialists and may not be mitigating the bank's losses either, as far as I can tell. So, good place to start. All right, let's start with the short sale addendum to listing agreement. Because a lot of this is seller education. I mean, educating them about the short sale process. But let's see, maybe on Lola here. That's the education part. But notice in red, owner's authorization to disclose short sale information. That's the real legal purpose of this thing, okay? Because owner acknowledges there may be disadvantages, okay? You're still educating them here. But A is the big one. Number 2A, disclose that the property is a short sale in the MLS. You're publicly saying that you're short selling your property at this point. Right? Because now it becomes public knowledge that you want to sell your property for less than what you owe. This really can be, at this point, stigma, even in 2010 when a lot of people are doing it, stigma can attach, amongst your neighbors, friends, business associates, whatever, to the fact that you're trying to sell your property in a short sale. So, as an agent, you need them to acknowledge that they're giving you permission to publicly say, yeah, we're short selling this property. So it's very important. I think that's, this paragraph 2 is the key to why you want to get this form signed for sure. Paragraph 3 is there. I think the best purpose for this is there's no surprises when you go into contract, because these are all the terms that are going to end up in the contract later on. Now, the next form, seller authorization for release of information. I mean, this is one. If you don't have this, you can't communicate with the lender. And really in a short sale, your key role in big pain in the patoot is communicating with the lender. The start of it is that you got to have written authorization to do so. So you simply got to get this form, or they won't talk to you. Now, they won't talk to you without it. It's that simple. And now the contract. The part in red is key here. Okay, you're acknowledging there's some education here. Defines what a short sale is. There's more debt owed on the premises than what the seller will net from the proceeds. Therefore, the contract's contingent upon the seller obtaining this written agreement with his lender regarding the contract. May take weeks or months or years. Cost thousands of lives. Seller's responsible to do what the seller's supposed to do. That's your documentation to the creditor. Now, here's where it gets interesting, though. Okay, this is where it gets interesting. If you sign these things without appending them in any way or amending them in any way, the seller can keep marketing the property, and a lot of times the bank's going to demand that. You try to get a better deal. The seller can continue to market the property, and if they get a better offer, they're going to send it to the buyer. Say, we got a better offer. You want to match it or beat it? Beat it or beat it? Number 4 is important, okay? Because this is where the clock starts. Because take these 3 contract terms together, 4, 5, and 6 here. And what they mean is this. You're in a short sale contract, okay? Seller is obligated to do certain things, but he can continue to market the property. On the other hand, the buyer is not obligated either. So neither party really is obligated under this agreement, under the terms of the contract. They're going to present the contract to the lender, and here's the thing. Once the lender signs off on the contract and delivers their approval to the seller, and the seller's agent then delivers that approval to the buyer's agent, now you're in contract. Now you're in contract. The buyer can no longer rescind the deal based upon the fact that, based upon all these previous short sale contingencies. The contingency satisfied, the contract moves forward. And the time clock starts. So you need a date and time when you send that agreement notice. It needs to be dated. You probably want to get something in writing that's been, or at least noted into your file that it's been delivered to the buyer's agent, because that time is when the contract starts, and your whole inspection periods and everything else go forward from that time. And obviously, in the event that the seller and the creditor can't do anything, contract's null and void, buyer gets their money back. Deal's done. Unless, of course, the seller won't agree to it. Yes, I saw you laughing at me. And this is just a recognition that, yes, you all may spend a bunch of money trying to get this deal done, and the lender won't agree to it. If you spend it, it's on you. Nobody's going to look to anyone else for their costs, because we're all counting on this third-party lender to make nice and agree to the deal, and they may or may not do it. Any questions regarding these forms? Yes?
I'm just curious, because I don't know that you actually can market the property, even though seller and buyer, seller agree, banker do anything yet. So does it mean that the listing agent does not need to change the status contingent upon maybe
I'm trying to clear up the question here.
because from this number 3 here on the short sale form, that the agent can still market the property, right?
The agent can still market the property if
That the agent does not have to put the, change the status in the MLS to contingent on financing. They have to?
that would be an MLS rule, I gather. Yeah.
We just had that where I failed to do it, and the buyer's agent said to me,
Yeah.
You have to put it in, you have to put it in.
That was, I'm not well versed on all the MLS rules, but that rule would logically make sense that you've got contingent upon.
Marketing it on the selling side, you have to put it in the MLS as contingent upon inspection and finance. You could put in the comments that you're still showing taking that.
Exactly. That's what I would do. Is you have to make that. You have to check that box and then fully explain that we're still accepting all offers because we're in a fully contingent short sale contract.
But by doing so, your chances of getting anybody to look at it are slim to none, because
Yeah.
no one wants to get involved.
Well, and
It's already in contract.
and if that gets to be a problem, I'd be talking to your organization about finding some other way to mark these short sales up, because they aren't going away anytime soon.
I don't think there is any way out of it. I think it's something that has to be.
Well, you could. You'd say you don't think there's any way out of it. What about having a separate designation that says, that says contingent, that's specific to short sales? Then you have,
But this is
then it properly explains what's going on.
not only for short sales, though, it's for all. I know there's gonna change it.
Right. Yeah. Your organization would have to make a change in their system, and they've done it before. I mean, They've done it before. It's a living, breathing thing. They can change it. You know, when I represent auction clients, and when auctions have become more mainstream, they've had to make changes to accommodate the auction process in the MLS too. But it happens. You know, they can do that. So, any other questions? Go ahead.
It does say here, unless otherwise agreed in writing. So can we just say the buyer does not agree to the third one and would not let you market? Because I had a buyer and I said, she's not gonna get into a contract if you're still showing it.
Right. The question is, can you agree to a situation where the seller does not have the right to continue to market the property? The answer is yes. You just got to write it. You just got to write it up that way and attach it as and say not and attach it as an addenda that says notwithstanding. Yeah, that's right. And number 11 has additional. Number 11 you can write under number 11. Notwithstanding, paragraph 3 above. Seller shall not market the property. Yes, sir. Excuse me? Long sale. Just say. Short on money, long on time. I mean, I've told you I'm sympathetic with what you go through here. You're spending twice as much time for half the money per deal right now, and it's that's just the way it is. Excuse me? Right. That's a good sound. That's a good sound idea. Yeah. You don't make your earnest money deposit until the lender approves the deal, and that's a fair, practical idea.
If they say you have to still market the property, yet you have to market as not inactive, contingent in the MLS, isn't that pretty much shoot yourself in the foot? I mean, like, isn't that like backwatering what you're really supposed to be doing?
You say you have to. Let me. I'm going to repeat this for everyone else. You're basically saying you're at cross purposes because on the one hand you're told you're going to market the property, and on the other hand you're putting it in this contingent upon financing. Yes, it is. And again, if this continues to be an issue, I think that the next issue here is to go to your MLS and say we need a separate designation for the situation where you're in a short sale contract that has yet to be approved by the lender, so that people know what's going on. You know, that would be my suggestion is to get after your MLS board. You know, they'll listen. They can look at these forms and see. They'll see the situation. You know, and they can do that. It's just another checkbox. You know. Yes, they have created plenty of checkboxes. It's true. So, anyone else? Okay. Got about 20 minutes left. Special contract situations. A lot of these are ones, this is 9, I think. A lot of these are ones where you might want to get a lawyer involved. Multiple offers. So, and actually this happened to my wife a few days ago, and I couldn't believe it. Where she put an offer on a property, they start to negotiate, and somebody else swoops in with another offer. And I said, really? In the biggest buyer's market, and since the Great Depression, you managed to find a property that gets more than one offer? Yeah. No, I'm sure she's not. It just struck me as funny in this particular market. But yeah, you're going to run into this. So you're negotiating with someone and you get another offer come in. So now you've got two live offers sitting in front of you. As an agent, the big thing to do here, there's lots of ways you can handle this. Okay, I think this last transaction, the guy said, well, by 10 a.m. tomorrow, send me your highest best offer. I'm not going to say whether they did or not. Let's assume for the sake of argument they did. Well, does it mean you accepted the highest best offer? Not necessarily. You could go back to A submits 200,000, B submits 205. You know, you go back to A and say, well, B said 205. What do you want to do, A? You can conduct your own little quasi-auction. And it's not an auction because it doesn't fit the definition under Ohio law, so you're not violating any licensure stuff here. You could, the thing you got to avoid doing is avoid putting out a situation where you say to both parties, I'll accept this, and then they both send it to you and you're in contract with two people. Right? Avoid the situation where you end up in contract with two different parties. That's a lawsuit waiting to happen. Right? That's the danger of a multiple offer situation. Be the master of your situation. Make sure that you're only accepting one offer. The question is an agent ethically required to disclose multiple offer situations? To whom? The seller's agent to the buyer's agent. Are they ethically required to disclose that there's another offer on the board? No, I wouldn't think so. Logically, that would be bad ethics. I think you see how you're, and that's exactly right. Your seller has to give you permission to say anything about that. I think the seller and the agent are being foolish if they don't. To say the least, they're being foolish.
Are they doing a fiduciary duty to their seller is if they don't put the offers out there and see if...
Well, the question is your fiduciary duty to your seller. Your answer is this. Mr. Seller, we now have two different offers. Here's what you want. My duty to you is to try to get the highest, best price I can for this property. Here's how I think you ought to go about it. But the choice is yours. That's your fiduciary duty. The choice, at the end of the day, you give him your most informed professional opinion and allow your seller to make the choice. That's your fiduciary duty. Your seller's agent's obligation to notify both parties. Again, they don't have any obligation to notify them about anything except their own separate deal. But what they do is their fiduciary duty, again, is to their client. And what they do is they establish what they're going to do to deal with those multiple offers and then follow through.
Out of cooperation, they should just tell the other offer, we have responded to another offer. That's what I've always done.
Well, out of cooperation, you can tell someone you've responded, but in terms of what you have to do, and better still, if you're going to do that, you better talk to your seller.
Right.
And say, I recommend we do this as a matter of common courtesy, but the choice is yours. Well, and you're right, and that has happened to people. Is you all deal in residential real estate, I suspect, for the most part, because that's why you're here today. But in a commercial transaction, it would be expected that if you had multiple offers that the agent play them off. In a residential transaction, people's emotions get involved, and now you got trouble because they get emotional about things. Well, they're offended by that kind of behavior that they would play us off against each other, which they should be doing, in my opinion, but, I'm just the attorney. But, yeah, I mean, you got to be careful. There's a lot to take into account in multiple offer situation. Yes, sir. Oh, yeah, and you're almost never going to see a situation where there's a written confidentiality clause. I've yet to see it in the residential context where somebody writes in and says, this is a confidential offer, you can't disclose it to anybody. You know, so yeah, you not only can you, but you know, in terms of your ethical obligation, you're almost compelled to recommend it as an alternative to your seller, that this is what we ought to do to make for you to get the highest, best price. But the choice is yours, Mr. Seller. Well, there's nothing you can do about that. All you can say is you're wrong. But you know, that's go take Fergus's course and you'll find out why. Yeah, we are running out of time. Yes, let's quickly. Next two are on there. New construction. I'm going to go through these quickly. New construction is the most complex transaction that a person can possibly do outside of being in business for themselves. Right? It's tremendously complicated to build a house from the ground up. There is a form. First of all, they really ought to be. You're going to do something like that. You really ought to have a lawyer involved. Usually the builder is going to interpose their contract. I can tell you for an absolute fact, it is a really biased contract towards the builder. If it's the standard BIA contract, shockingly biased contract. They need to be careful. They need to get a lawyer before they enter into that contract. During the process, there is a checklist form that can help you out, that can help guide them through the process. Use it. Yeah, but there really ought to be a lawyer. I mean, it's a bad bad. You know, from a consumer standpoint, it's not a pro-consumer contract. It's that simple. Condominium purchase. It's another thing where if some people can't afford the lawyer, fine, but they're buying a $50,000 condo. I get that. And dollars are scarce, but when possible, when you buy a condominium, you're not just buying the housing. You're buying a relationship. You're buying a relationship with all the other members of the condominium association, and you're buying their finances. You're buying into their finances. So you need someone to check on a variety of things to make sure that they're holding proper reserves, that they're getting things done. Check to see what things are likely to be needed to be done in the future, what they've done in the past. There's a lot to look at here. There is a condominium checklist in your materials. Use it. Representing a condominium owner buying a condominium is somewhat complicated because that which they're buying is not simply dirt in a building. Purchase from a financial institution. Well, we've gotten into that already today, but to summarize, you're buying from a financial institution, this is what's going to happen. They're going to interpose their own contract on you. Right? They may call it an addendum, but it basically will rewrite your contract for their terms. You're not going to get a residential property disclosure form, so you need to be really careful about your inspection. You're going to probably be taking it as is, where is. You're going to get a limited warranty deed, so the deed is of somewhat less character than the deed you would typically get in a residential transaction. All they're saying is we're warranting that which we know about from the time that we've actually owned the property, which is about 3 months. Okay, and you're going to have your client's probably going to have to pay for title insurance, and they're going to be forced to get that title insurance from an out-of-town title agent who has less than perfect knowledge of the local marketplace and may do a somewhat sloppy search and examination of the search as a result. So, A, yeah, get a lawyer. B, at a minimum, this is where that relationship with your title agent is valuable. You can have that title agent at least look, if nothing else, have them look over have that title agent friend of yours look over the commitment. See what's there.
Sometimes we find title closing courtesy, his attorney's office, and then checks are not got for 2 to 5 days. So think about picking up your real estate.
That's true. That's true. I mean, the closings are. I've been to a couple of these closings, and they can be kind of screwy. Your checks aren't cut right away. You're waiting around the office for time after time because things aren't quite getting done right. There isn't someone right there to crank out forms in case or change deeds in case some little thing went wrong. Yeah, it can be a little rough. No question about it. Purchase of rural property. Let me do this I'll do this in reverse order. Non-traditional sales. I'll take first and we'll do the other one last. I'll give you I got a story on this other one. Non-traditional sales. People moving out of town can't afford, they don't qualify for a short sale, or they don't want to do one. They got to go. They're upside down in their house, or they just can't sell it for whatever reason. They want to do a land contract or a lease with an option to purchase. Want to owner finance the thing. Any of that stuff, get them to get a lawyer. 10, magic number. I told you I'd make double digits. There it is. All right, tell them to get a lawyer. You don't want to get into these drafting situations, and indeed, I've had people call me and say, we want to sell a house in a land contract. As a lawyer, I say, no, you don't. They're terrible, and they have to know they have to have an informed opinion of what their alternatives are. Why are land that's the subject of a course. Why is a land contract terrible is almost the subject of a course in and of itself. Especially for the seller, the land contract is supposedly, at least, a consumer protection device. So people go into them and say, for example, well, we'll take a $5,000 deposit, and if they renege on the land contract, we'll cancel the land contract and get our money back. Well, they don't work that way. You can't have a non-refundable deposit in a land contract. They're always refundable. Well, at least we'll get our rent. Well, maybe you will and maybe you won't get your land contract payment. If the payments, they could go into court and argue that the payment was more than the fair market rental value of the property. They could get money back that way. Okay? After 5 years or after 20% of down payment, you got to be careful. Now it's as if they're owners. Now you have to foreclose on them. There's a lot there. I got 5 minutes. I don't want to take up too much time with it. Trust me, land contracts, and I think virtually every member of the real estate bar will tell you the same thing. Land contracts are a terrible idea. Yeah, if you're the buyer, they're okay, except for the confusion factor. And there's a lot of confusion that goes into them. Last but not least, the purchase of rural property. Rural property can be, I was talking to somebody here, rural property can be very messy. Typically, rural property has zoning issues or lack thereof, lack of zoning. You might have access issues. This is where you're going to find multiple parcels. You're going to find land uses next to you that may be incompatible with what your clients really want. There's all kinds of a variety of issues that need to be dealt with in a rural setting. You really got to know what you're buying, and you really got to know the legal background behind what you're buying, and you really got to know about the easements and possibly even oil and gas leases on the property. All kinds of fun stuff happens in the rural areas. Excuse me? Oh. Yeah. Hire a lawyer. There's Levin. Yes, there we go. Okay. Get a rural attorney. That's right. Okay. Here's an example. Okay. Several years ago, when I was working up in Delaware, a guy comes to me. They're in a subdivision that has a great view of the Scioto River. Okay. And it's a minor subdivision. I think there's like 4 or 5 parcels in this subdivision. You know, just kind of created on the fly, not particularly well done. You know, it is this kind of thing that happens in rural areas. You know, not a high degree of professionalism on this one. But the properties are kind of stacked up the hill, okay? And my guy's got the one at the top of the hill with a great view down the hill. He originally comes to me because the guy in front of him is insisting upon putting a driveway around the back of his property, and he didn't have any right to do it, so I had to go to court and stop that. Well, a few months later, we found out why he wanted to build the property. Turns out he wanted to build a gym in back of his house, a 3-story gym in back of his house. Now, I could use all my powers and all my skills to slow that thing down and make him only use his own property and what his property rights were to get the building process going. But just as a matter of fact, because of the way the deed restrictions weren't written, he had a right to build a gym and block this guy's view. And build it he did. Not only did he build it, but these guys were so contentious that by the end of the process, in order to exact his revenge, the guy who built the thing put a window with a smiley face on top of the building, pointed at my client. Yeah, you got to know what, in a rural area, you got to know exactly what your client wants to do with the property, what makes them happy about the property, and then make sure they can actually do it. And they're actually going to keep their rights, because the rural areas, you know, sometimes you have zoning, sometimes you don't. I mean, otherwise they can kind of be the wild, wild west of land use. Anything goes. So, open it to any questions now. We got about 2 minutes left.
How can a buyer sue a seller for performance, and is it worth it?
How can a buyer sue a seller for performance, and is it worth it? Okay. Well, everybody wants to get out because it's 4:30. I will entertain questions up front here. I want to thank everybody for coming. I appreciate the questions. I enjoyed it. Thank you.